Hi, I'm David Shipler.
And I'm Daniel Zwerdling. Two reporters. Start now. Hi, Dave.
Hi, Danny. How you doing?
Good, thanks. Our guest today says she remembers the exact moment she realized, OMG, not her exact words, I need to research the emergency powers that a U.S. president can use.
November 9th, 2016. I can very easily put a day on it. That's when I started to think about what President Trump might do in the event of an emergency.
Elizabeth Goitein co-directs the Liberty and National Security Program at the Brennan Center for Justice. She used to be a trial lawyer at the Justice Department. She's discovered that over the past 100 years, Congress has passed dozens of laws that give the president extraordinary powers in case there's a national emergency.
And Liza says, look, obviously it's good government to prepare for the unexpected. She says the problem is some of the president's emergency powers are scary.
When the president declares a national emergency, there's a law that allows him to take over or shut down radio communications facilities. If he goes further and declares a threat of war, just a threat, there doesn't have to be any proof or any actual conflict going on, he can then take over or shut down wire communications facilities. The last time this law was used was during World War II. If it were invoked today, in theory, there's at least an argument that wire communications facilities could be interpreted to include much of the infrastructure for the internet. And if that were the case, then the president could use this provision to take over or shut down internet traffic inside the United States. And all he would have to do is say, there's a threat of war.
And you found buried in the federal law all over the place authorizations for emergency powers, didn't you?
Yeah, although I wouldn't even use the word buried. I mean, they're not that hard to find. It's just that ordinarily people don't pay any attention to them. Because ordinarily they're not being used for the most part. They're not affecting people's lives. And so there wasn't a whole lot of awareness about these powers, either among the public or even among lawmakers.
Well, you say they're hidden in plain sight. I think that's about the right way to put it, because they're there, but most Americans have no idea that any of this existed, I think. I certainly didn't.
Let's go to another example that you say has worried you, and this is the International Emergency Economic Powers Act, passed in 1977. That doesn't sound, on the face of it, particularly scary.
Doesn't?
Well, tell us what.
Anything with the word emergency in it sounds a little bit scary to me. Well, to the extent people have heard of this authority in the past, they probably associate it with sanctions, economic sanctions that are levied against hostile foreign actors, such as the government of North Korea, for example. Countries like Iran or Syria, or terrorist groups or cyber criminals or international drug traffickers. And yes, in a situation like that, it's kind of hard to object to it. It doesn't seem that scary. What's frightening about this law, IEPA is the acronym, is what it allows and how broad it could be if a president decided to sort of push it to the limit. IEPA allows the president to freeze the U.S.-based assets of these targets and also to prohibit any person or entity that comes under U.S. jurisdiction from doing any kind of business, any kind of financial transaction with the target.
What happens to the American who's designated?
That means that banks cannot process any financial transactions involving that person. No company under U.S. jurisdiction can offer the person a job. It really is to the point where you can't even sell groceries to a person who has been targeted unless the government gives specific permission. So if you want to do any kind of business with someone who's been targeted under IEPA, you have to apply to the government for a license. The government can decide to grant it or not. It is entirely within the government's discretion. And so essentially, this law can be used to just freeze a person out financially. They can't receive money. They can't pay money. It's really the equivalent of a financial death penalty.
And has it been used in that way against any American or or American resident?
Yes. There's a man named Garaj Jama who had a business that involved sort of getting money to immigrants' families overseas, essentially. And the government suspected that this was part of a terrorist financing network. That turned out not to be the case. In the end, the sanctions against him were just dropped. But in the meantime, there was a terrifying period for this person where he had been publicly branded as a terrorist, because that's part of it. There's a public announcement that says, you can't do business with this person because we think he's a terrorist, supporting terrorism. He couldn't get a job. He basically couldn't do anything. And he tried to get in touch with the government. He tried to apply for a license so that he could have a job. Nothing, no response.
So just to clarify that, because he was designated, he needed a license to do any financial business in the United States? Is that it?
Yes.
Oh my gosh.
No one could do any kind of business or financial transaction with him without permission from the government. And the scary thing is, when he asked for that permission, the government ignored him and just didn't respond for months. And he finally, to get their attention, he had to file a lawsuit. But guess what? You can't pay a lawyer without permission from the government under some of these regimes.
Sounds Kafkaesque.
It's Kafkaesque.
Is there any proof required?
The government says that it follows a rule of having a reasonable basis to believe that the person in question contributes to the threat.
Sounds like a pretty low bar, doesn't it?
It is a low bar, and part of the problem is that the executive branch, the government agency in charge, which is usually the Treasury Department, makes this determination based entirely on information it puts together, which can include hearsay information that would never be admissible in a court. Much of it is classified. And the Treasury Department makes its determination, but does not have to share that information with the person who's been targeted. And the person who's been targeted can petition to be delisted, is what it's called, basically untargeted. But given that they have no right to actually see the government's information, they don't necessarily know what they're responding to. Plus, the government at that point has as long as it wants to respond to the petition. There's no deadline. It can take years. And then it issues a written response in which it says, sorry, we decided that we're not going to grant your petition.
Liza's going to tell us in a moment about more emergency powers that in some ways she thinks are even more frightening. But first, let's break away from our recorded chat to add a little history. Liza says presidents might use two main types of emergency powers. The first are powers that Congress voted to give the president. They're known as statutory powers. Statutes are laws passed by Congress.
This is all the stuff I forget from civics back in 8th grade.
If you even were taught it, Danny.
Exactly. I don't remember being taught it. In any case, so for example, Congress passed that emergency law that Liza talked about that could allow a president to basically destroy a person's finances. They did that back in 1977. And Liza says, ironically, Congress was trying to rein in emergency powers that had been voted in back during World War I. But she says Congress ended up by just making some things worse.
And Congress passed the laws that could allow the president to take over telecommunications before and during World War II. Picture it. There were not really advanced telephone and telegraph communication systems then. They weren't computerized. When you made a call, you had to go through an operator. And of course, the internet didn't exist. And Congress worried that the president might have to commandeer the country's communication system so military and government leaders could easily communicate. Those emergency powers are still in effect.
But in addition to laws like that, which Congress passed, some presidents since the Civil War, and now we get to the heart of the next kinds of powers, some presidents since the Civil War and the raids have claimed that Article 2 of the Constitution gives them authority to do pretty much whatever they want during emergencies, no matter what Congress thinks. Back to our chat now with Liza Goitein.
Article 2 does say that the executive power is vested in the president, and it also makes the president the commander-in-chief of the armed forces.
What's the first sentence? Something about the president shall be the...
Well, I can pull out my copy of the Constitution, which I keep right on my desk, if you'd like.
Speaking of the Constitution, I just want to mention that David Shipler is holding up an actual copy of the Constitution. Do you really keep this on your desk all the time?
I do, yes, absolutely. And I actually refer to it on occasion when I'm writing about things. I just looked up the First Amendment the other day because I gave a talk on journalism. And although
So what about the second? Could you start Article 2?
Article 2. Oh, yes, Article 2. So the first sentence in Article 2 of the Constitution says, the executive power shall be vested in a president of the United States of America. And then when you go down to Section 2 of Article 2, here's that first sentence, a key one. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States.
And those particular authorities are the ones that are sometimes relied on by administrations that claim to have inherent emergency powers. So sometimes it's, well, this relates in some way to armed conflict, and therefore, as the commander-in-chief, I can do anything I want that relates to war. We've certainly seen this expressed after 9/11 in terms of the administration of George W. Bush arguing that the president could essentially ignore the laws about torture and on warrantless wiretapping because there was inherent authority that the president had in order to take these actions.
And now listen to this. Liza says presidents and their aides have used that argument. Hey, Article 2 of the Constitution gives me, the president, the power to do whatever I think is necessary. She says they've used that argument in part to draw up emergency plans that almost nobody knows anything about.
It sounds unbelievable in a pluralistic democracy.
These are called presidential emergency action documents.
These are presidential orders and directives that are prepared in anticipation of a wide range of worst case emergency scenarios. They originated under the Eisenhower administration as part of an effort to plan for a potential Soviet nuclear attack. But they've expanded since then to address other types of emergencies. They are entirely secret. They are some of the most secretive documents that we have, in the sense that none of them has ever been publicly released. None of them has ever even been leaked.
Really? Not a single one? Not
a single one. So the only way we know about their contents is through references in other official documents, FBI memos and things like that in passing sort of describe some of their contents. But that's enough to be scared, because what these other official documents show us is that the presidential emergency action documents that were in existence at least up to about 1970, which is sort of the latest point from which we have any information about their contents, purported to do things that seem blatantly unconstitutional. They purported to impose martial law, to censor the press, to authorize the roundup and detention of people on an index of subversives, to seize property without warrants, and a whole list of things that kind of send chills up your spine when you read about them. We don't know anything about the contents of more recent presidential emergency action documents, but the whole idea of these documents is to imagine how far a president might need to go in an absolute worst case scenario. The idea is to imagine the outermost limit of the president's authority and then get ready for a situation in which the president might have to exercise that. We also know that at least as of 2018, under the Trump administration, these documents were undergoing review and updating. And we know that because of some budget requests that were submitted to Congress. And so right there, that's another reason I worry, because I'm thinking, what did Attorney General William Barr think were the outer limits of President Trump's authority?
And these really chilling ones that you talked about, do you have any idea whether they're still in effect?
No, we just don't know. And one of the reasons it's a question mark, I mean, it's certainly a question mark for us, for you and me, for members of the general public. One of the things that's most disturbing is it's also a question mark for Congress, because these documents are not shared with Congress, despite the fact that even the most sensitive covert military and intelligence operations have to be shared by law with at least the Gang of Eight, which is the people in key leadership positions in both the Senate and the House. But these documents are not shared with Congress. So there is no oversight. And that's what's worrisome about them, frankly, because the fact that the government is preparing in advance for worst case scenarios and wants to have directives and orders in place, that's a good thing. Advanced preparation for emergencies is not itself a problem. What's a problem is when you find out that some of these documents, some of these directives purported to do things that were blatantly unconstitutional. And in combination with that, the fact that there is no transparency and no oversight by Congress. That's when you have a recipe for autocracy.
We're talking with Elizabeth Goitein. She's co-director of the Liberty and National Security Program at the nonpartisan Brennan Center for Justice.
Where is Congress in all of this? I remember reading in something of yours that when it comes to national emergency powers, Congress is supposed to regularly review them, right? And decide, okay, this power has been in effect for 6 months, it's over. Or, okay, let's extend it for a little bit. But you say there have been some emergency powers that have been on the books and are still in effect for decades.
The National Emergencies Act tried to rein in the president's use of emergency powers in 3 ways.
And that was in 1976.
The act has now been in place for over 40 years. And the first thing it did was to provide that a presidentially declared emergency would expire after a year unless the president renewed it. And the idea was that expiration after a year would be the default. That didn't work out because it turned out that presidents were perfectly happy to renew after a year. All they had to do was put their signature on an executive order. And so renewal year after year after year has become the default. And most emergencies now last for a decade or longer. The second safeguard that the National Emergencies Act put in place was a requirement that while an emergency was in place, Congress had to meet every 6 months to consider a vote on whether to terminate the emergency. And the act has now been in place for over 40 years. And for most of that 40-year period, Congress did not meet even once. Congress never met to consider a vote on whether to terminate an emergency until 2019, when President Trump declared an emergency to build the border wall. At that point, Congress finally did meet, and they voted to terminate the emergency, and the president vetoed it. The third safeguard in the National Emergencies Act is that Congress at any time can terminate a national emergency declaration by a simple majority of both houses without the president's signature. Legislative vetoes were held unconstitutional by the Supreme Court in 1983. So that provision, which was actually the key check against presidential exercise of emergency powers in the National Emergencies Act, that provision no longer exists. Instead, to terminate a national emergency declaration, Congress has to pass a law with the president's signature. Now, presumably the president won't sign it since the president's the one who declared the emergency. And so then Congress needs a supermajority in both houses of Congress in order to override the veto. Functionally impossible, I would say, in today's environment.
So the bottom line is some presidents think there's no check on them.
Even though the Constitution doesn't give the president any express emergency powers, that has not stopped modern presidents over the last several decades from asserting that they have inherent powers under the Constitution. And this is actually a sort of growing trend where increasingly presidents are claiming to have broader and broader inherent powers under the Constitution.
I guess to be fair, we should stress that it's not just Republicans who have tried to assert this, like Trump, but Democrats too, that Article 2 gives them extraordinary authority.
Absolutely. This is not a partisan issue. This is an institutional issue among the branches of government, that the presidency has grown stronger and stronger. And at the same time, Congress has been delegating away more and more of its authority and actually just abdicating its authority in situations where the president usurps authority that Congress hasn't given the president. So if you look at, for example, the way that presidents from both parties have interpreted the authorization for use of military force after 9/11. That authorization was limited to essentially al-Qaeda and the Taliban. It's been used all around the world for all kinds of groups and terrorist groups, some of which did not even exist on 9/11. But Congress has acquiesced and has done next to nothing to actually stop this. And meanwhile, the courts, like Congress, are sidelining themselves and are increasingly asserting or raising sort of jurisdictional reasons why they can't get to the merits of some of these cases of presidential authority.
Well, you mentioned the courts. What do you think? Looking at the case law, there isn't a lot in this, is there? But what's the record in the courts in regard to emergency powers, do you think?
Now, most of the cases that have come before the Supreme Court when it comes to exercises of emergency powers have not dealt with statutory emergency powers. They've dealt with claims by presidents that they have an inherent authority under the Constitution to take some kind of action. This issue has come up so rarely, and the court in general has been so careful to rule just on the specific facts of that case, that there is still a lot of uncertainty as to what are the outer limits of a president's inherent constitutional authority during emergencies. We really don't have a clear answer to that question. I want to be very clear. Statutory emergency powers are very frightening, a lot of them, but they are not infinite. And when a president declares a national emergency, that does not enable him or her to do anything they want. After the election and after Congress certified the results, there were a lot of wild theories out there about ways that the president could invoke emergency powers to hold on to the White House despite the election results. Things like he could declare martial law, he could declare a national emergency, as if somehow declaring a national emergency would itself set aside the results of the election. Or he could suspend the Constitution, which is not a thing. There is no power, emergency power or otherwise, that allows the president to suspend the Constitution. So I think it's important to understand that while emergency powers are quite broad, and some of them in particular are quite frightening, they are not infinite.
Why didn't you tell us that then? We were all worrying.
I did.
We just weren't listening. Right?
Yeah.
Would an unscrupulous autocratic president be able to do anything with emergency powers before an election?
Again, the president couldn't do anything and everything with emergency powers at any point. However, there are emergency powers that I think could be used in ways that could very much undermine democracy and threaten the integrity of an election.
So give us a little movie here, a realistic movie, even if it's your worst nightmare. What could a president do, knitting together these various powers you've talked about and the many you have not?
What I worry about is a scenario in which the president, let's say the president posits some kind of foreign threat of war. Maybe it's Iran, maybe it's North Korea, and invokes IEPA, the International Emergency Economic Powers Act, to impose sanctions on anyone who is providing significant support to Iran or to North Korea or whoever it might be. And at that point, sort of trumps up reasons to designate Americans who are causing problems for the president's reelection prospects. And let's say there are organizations in particular that the president says are providing support through their actions to these entities. And the president can sort of starve those organizations financially, or major donors to the other political party, who could then be sanctioned and starved financially.
And while we are in this worst case nightmarish scenario, couldn't the president, under one of the first emergency powers you talked about, take over like communications networks, not just on the internet, but radio?
Yes.
Perhaps television?
Yes. You could imagine the president saying, because there's a threat of war, he needs to shut down websites that are promoting disinformation. And so then the president could target websites. Now, listen, I'm not saying that any of these things I'm certainly not saying they're legal. I think a lawyer could stand up in court and make a very good argument that the president is exceeding his authority under the law if he does that. But there's an argument on the other side. if you look at these statutes, and you don't know what the courts are going to do. And so I think there are ways of undermining civil society with an election coming up. These types of actions would presumably lead to protests, and then those protests could be met by exercises of emergency or pseudo-emergency authority in the form of deploying troops. And the troops could be deployed in ways that were intimidating to people who are trying to conduct political activity, maybe trying to organize around the election, and could even make it harder for people to vote. Again, there are laws against interfering with people's ability to vote in an election. But I think the very fact that those powers exist to do those things is something we need to be very, very worried about.
Well, you have drawn a troubling landscape. I think we all understand that emergencies do arise and that at least short-term and very precise powers might be needed in certain situations. But the broad scope of the powers that are lurking there, possibly waiting to be invoked by an unscrupulous president, are pretty worrying. And I guess the question is, what are the remedies? What do you think Congress could do to change this landscape and set boundaries?
Trump's national emergency declaration to build a border wall that Congress had expressly refused to fund was a big wake-up call for Congress. And so we are seeing movement. We are seeing some momentum in Congress to reform the National Emergencies Act, to make it easier for Congress to shut down abuses of that power. The main reform proposal is an approach under which a presidentially declared emergency could only last for 30 days unless Congress affirmatively voted to approve it. And at that point, it could last for up to a year. But again, if the president wanted to then renew it for an additional year, Congress would have to vote again to approve that. This is a very simple sort of common sense reform that aims to restore the balance of power, essentially, between the president and Congress. And it's very popular. It has a really surprising amount of bipartisan support. And a lot of Republican lawmakers who weren't willing to challenge President Trump specifically on the border wall emergency were willing to get behind this idea that emergency powers in general really should be reformed in a way that gives Congress more of a say.
So if you were going to bet, what would the odds be that you would put on this passing?
It is so hard to say. And external events play such huge and unforeseeable roles in these things. As I said, there was there still is a lot of bipartisan support behind this approach. But obviously, in the wake of the insurrection on January 6th, it's much harder for members of Congress to work across the aisle right now. And I think that's sort of put a temporary delay on a lot of bipartisan efforts. I don't think it's a permanent delay, but that's just an example of ways in which external events can affect things in ways you might not foresee. So it is really impossible to game this out. I'm not trying to dodge your question. All I can say is that I have not seen in my now fairly long experience of doing this kind of work and this kind of advocacy on the Hill, I have not seen an issue get this broad and deep support across both parties.
Liza, it seems to me there's one piece of evidence that suggests that you worry too much.
Yeah.
I can imagine a lot of people thinking, no president has ever done all this stuff. They've done something here, they've done something there, but nobody in all these, 200 some years has ever knit together all these emergency powers in the way that you were suggesting they could be, and that I was urging you to imagine. Mm-hmm. So shouldn't we relax?
I think if you were a Japanese American during World War II, you might have a different take on that. I think if you were Hamdi, who was an American who was detained after 9/11 as an enemy combatant, incommunicado with no lawyer, no due process, I think you might have a different take on that. There are a lot of Americans whose communications were picked up by the NSA after 9/11 who don't even know because the government doesn't have to notify them that their privacy was breached in that way. We have not seen a perfect storm of abuses that completely upended our democracy. But is that really our standard? Are we willing to allow emergency abuses as long as they, fall short of converting us from a democracy to something else entirely? I would say no. And I would also say that the incidents that we have seen over history, and particularly under the last administration, under President Trump, Those are proof of concept that emergency powers can be abused to very effective ends by presidents. And I don't think that lesson will be lost. And so I worry. Yes, I worry. I do think the fact that we have not seen an absolute worst case scenario in terms of abuses of emergency powers to date in no way means that it can't happen or that it won't happen. And why would you not? Why would you not try to prevent that when you can? We see these problems, we see these holes in the legal regime that could permit things that we all agree would be terrible if they happened. Why not do something about that?
Elizabeth Goitein, thank you so much for sounding the alarm.
Yeah, you got it.
Yes, thank you so much, Liza.
Yeah,
This
sure.
has really been...
Thank you for picking up on it and giving it getting it out there.
Thanks. Bye.
Elizabeth Goitein co-directs the Liberty and National Security Program at the Brennan Center for Justice. And that's it for this episode of Two Reporters.
You can hear us on Spotify, Audible, Stitcher, and other popular podcast sites. And you can listen on our website, tworeporters.org. Plus, we have tons of other information there. Please check it out. I'm David Schiffler.
And I'm Daniel Zwerdling. Please join us again soon for another episode of Two Reporters. Bye-bye.